Hi, I'm former congressional candidate Joe Kopsik. At 10 a.m. Eastern Time on the morning of Friday, June 22, 2012, the U.S. Supreme Court made a decision on the constitutionality of the Patient Protection and Affordable Care Act, colloquially known as Obamacare. At the time of the recording of this video, Sunday, June 24, 2012, the Supreme Court's decision on the matter has not yet been revealed to the public. I would like to explain why I believe the law is unconstitutional, with special attention to the law's relationship to the Interstate Commerce Clause, Article 1, Section 8, Clause 3 of the U.S. Constitution. It shall first be necessary to provide some background on that clause, which hereafter will be referred to as the ICC, and on its interpretation. The ICC reads, "The Congress shall have power, quote, to regulate commerce among the several states," end quote. In my view, and in the view of many strict constructionists, regulate should not be construed to mean legislate on, nor prescribe the rules for governing, but rather keep regular, that is, uninhibited, uninterrupted, and uncontrolled. I and many strict constructionists believe that the purposes of the ICC include giving the federal government the power to prevent and reverse any attempts by states to create barriers or impediments to free trade across state borders, including tariffs or importation fees, and to prevent trade wars between the states. Two effects that these purposes have are, 1. To turn the nation into a free trade zone, and 2. To prevent state governments from inappropriately pandering to the industries and businesses within their claimed territorial jurisdictions by protecting them. Such protection may come in the form of regulatory favors, or in the mercantilist sense of economic protectionism, i.e. taxpayer subsidization. Commerce has been held by the Supreme Court to mean intercourse, which includes traffic and navigation. Being that the constitutional philosophies of strict constructionism and originalism have a great deal in common, and that originalists feel it informative to inquire as to how certain important words were defined when the laws containing them were written, it would be appropriate to mention that a dictionary printed in the 1790s defined the word commerce in its verb form to mean to hold intercourse. Supreme Court precedent supports the notion that intercourse includes exchange and interchange. As I stated earlier, commerce is not strictly traffic and navigation, but includes traffic and navigation, so it would seem reasonable to assert that commerce also includes the component of economic exchange, interchange, and/or transaction. Hence, I feel that it would be reasonable to define commerce and commercial intercourse as, quote, travel, traffic, and navigation used to conduct and facilitate economic exchange, interchange, and/or transaction, end quote. I will next explain which types of state-sponsored activities I and many strict constructionists feel are, and of right ought to be, prohibited by the ICC. The first type of activity pertains to distinctions between interstate and intrastate activity, and between manufacture and commerce. In the 1888 case Kidd v. Pearson, which pertained to the manufacture of alcohol, the Supreme Court held there to be a distinction between manufacturing and commerce. The effect is that state prohibition on the manufacture of goods within a state, for sale out of state, does not conflict with the ICC, and that such state prohibitions are constitutional. However, in discussing contraception in a Republican debate earlier this year, presidential candidate Ron Paul made a statement which implied that if the importation of a good into a state cannot be banned, then the good can also not be completely banned within a state. While I have not encountered any information which would indicate that there exists any precedent supporting Dr. Paul's position, my opinion supports a compromise between these two viewpoints. Although my ethical position is that no state should prohibit the manufacture of any good, a position which I take for various reasons related to contract rights and the conditions for legitimate consent to government, my constitutional law opinion is that while states should have the power to prohibit manufacture of certain goods, they should not have the power to prohibit the possession of goods, nor to prohibit their importation across state lines. The second type of activity pertains to what constitute inappropriate inhibitions, interruptions, and controls of interstate commerce. Views expressed by the Founding Fathers in the Federalist Papers support the notion that the ICC should prohibit the enactment of tariffs, tolls, and other taxes on the importation of goods. In the 1942 case Wickard v. Filburn, the Supreme Court ruled that quotas can be imposed on the possession of goods whose existence is deemed to substantially affect interstate commerce. Although I am not aware of any case that could be cited as precedent to support the notion that the ICC should prevent the imposition of quotas, it is widely acknowledged among strict constructionists that the Wickard decision was one of the most inappropriate, overreaching decisions in the history of the court, and that with it began the entrenchment of precedent supporting a loose definition of what substantially affects interstate commerce as a justification for federal intervention. It is this loose definition, which as far back as 1824 in the decision in Gibbons v. Ogden, redefined among the several states as intermingled with the several states, that has been construed to justify the need for laws like Obamacare, among many others. The third type of activity pertains to exclusive intrastate monopolies. In my opinion, this is the only type of activity of the three I have mentioned which pertains to the Affordable Care Act. The necessity of Obamacare seems to be predicated chiefly on the notion that health insurance companies should be permitted to compete across state lines, which in my view is a perfectly legitimate objective, and one that merits and requires federal intervention in order to address. I believe the commercial exchange should be construed to include the purchase as well as the sale of goods and services. I also feel that it would be just as unfair and inhibitive of economic activity, thus meriting and requiring federal intervention, for a state to give itself or businesses within its jurisdiction the sole exclusive power to sell a good or service, monopoly, as it would the sole power to buy a good or service, monopsony. Health insurance, of course, being no exception, given that the purchase and sale of health insurance does indeed constitute economic activity, and, it would seem, commercial transaction. I am not aware of any business that has been awarded a state-upheld exclusive monopoly on the sale of health insurance. Being that people with physical, tangible bodies who are capable of dying, and not businesses, which are abstract, potentially perpetual institutions, need health care, it would be ludicrous to consider the possibility that any business has been awarded a monopsony on the purchase of health insurance. Furthermore, since health insurance companies, and not governments, sell health insurance, it is obvious that no state has given itself a monopoly on the sale of health insurance. But the question remains of whether any state government has given itself a monopsony on the purchase of health insurance. As I stated earlier, such a system would be an unfair inhibition of commerce which would merit and require federal intervention in order to resolve. Moreover, as I explained earlier in regards to businesses, it would be ludicrous to conjecture as to why an abstract, potentially perpetual institution like a state government would need to purchase health insurance. Being that businesses and governments purchase health care on the behalf of their workers and citizens, there is no need to proceed along such an absurd line of logic. Rather than immediately answering whether any state government has given itself the sole, exclusive power to purchase health insurance, it will first be necessary to delve into the history of constitutional law surrounding health insurance. An issue that should be addressed is whether the sale and purchase of health insurance constitutes commerce. In the 1869 case Paul v. Virginia, the Supreme Court held that, quote, issuing a policy of insurance is not a transaction of commerce, end quote. To cite this case's precedent would seem to support the notion that the federal government has no constitutional authority to regulate the health insurance industry, either to require the purchase of insurance as a corollary to permitting health insurance companies to compete within states, or to prohibit the interstate purchase and sale of health insurance. However, this is not the case. In the 1944 case United States v. Southeastern Underwriters Association, the Supreme Court held that the Sherman Antitrust Act of 1890, specifically the provisions which prohibited artificial, unnatural, and coercive monopoly and business activities which reduce competition in the marketplace, applied to insurance. The effect is that the federal government can regulate insurance, not because the Paul decision was wrong in holding that issuing an insurance policy is not a commercial transaction, but because the market for insurance can be compromised by the forms of artificial monopoly and inhibition of competition which are prohibited by the Sherman Act. Something else to examine, keeping in mind that the decision in Paul v. Virginia was that issuing a policy of insurance is not a transaction of commerce, is whether the failure to buy health insurance really constitutes a transaction of commerce. In an article from late 2011, David Ladd expressed the opinion that refraining from purchasing health insurance does not constitute transaction, but that it instead constitutes failure to engage in commerce. The same article, in summarizing the views of former U.S. Solicitor General Paul Clement, explains that the individual mandate, quote, orders people to buy health care insurance, end quote, and then, quote, regulates that which it has forced you to do, end quote. It forces a person to engage in what is ostensibly commerce, rather than regulates ostensible commerce which already exists. Additionally, despite all the rhetoric that there is need for legal reform to address the problem of the healthcare costs of the uninsured being passed along to everyone else, it is health insurance, not health care, which Obamacare regulates. However, according to Professor Lawrence H. Tribe, it is economic activity to make other people pay for your health care. According to the aforementioned article by David Latt, that is, quote, what ends up happening under the status quo without the act, end quote. I would argue that Obamacare ensures that this happens, and furthermore that it causes particular people, i.e. the taxpayers and those who may be required to purchase insurance under the provisions of the Act, to pay for other people's health care, rather than simply causing some unspecified collective of persons or agencies to pay, or causing the cost of health care not to be paid at all, which is the actual status quo. The McCarran-Ferguson Act was passed in 1945, the year after the Supreme Court ruled in the case of U.S. v. Southeastern Underwriters Association that the ICC held that the court had the power to regulate the insurance business. McCarran-Ferguson does not regulate insurance, nor does it require the states to regulate it, but rather it allows the states to regulate insurance and preserves certain state insurance regulations. The Act also provides that federal antitrust laws and acts of Congress that do not expressly purport to regulate the business of insurance will not preempt states that regulate insurance. Additionally, the Act exempts the business of insurance from most federal regulation, including federal antitrust laws, except those that pertain to cases of boycott, coercion, and intimidation, whether the states regulate in that area or not. In a partial dissent in U.S. v. Southeastern Underwriters Association, Supreme Court Justice Robert H. Jackson called the idea that insurance is not commerce a fiction. Had Jackson been in the majority, it appears that the decision in the case would have had the same effect, but for a different reason. The reason being that the sale and purchase of insurance would indeed be considered commercial transaction, and thus eligible for federal intervention in certain cases. I would note that, given the outcome of the aforementioned case, it seems that the Sherman Antitrust Act and the McCarran-Ferguson Act are more effective in preventing inappropriate inhibitions of interstate economic activity than is the ICC itself, in that they have been held to apply to the business of insurance, which has somehow been deemed to exist outside the realm of commerce. Now to address the relationship between McCarran-Ferguson, interstate insurance monopsonies, and Obamacare. The McCarran-Ferguson Act provides that states may regulate insurance freely, unless federal antitrust laws or acts of Congress that expressly purport to regulate the insurance business preempt state laws. This would seem to give Congress the authority to regulate the health insurance industry, as long as Obamacare expressly purports to do so. However, I have become aware of no such expressed claim in the Act that its aim is to regulate the business of insurance. I have, though, heard proponents of Obamacare cite the ICC to defend the Act's constitutionality. Being that Paul v. Virginia and U.S. v. Southeastern Underwriters Association hold that insurance is not commerce, the ICC does not support the constitutionality of Obamacare. On the other hand, McCarran-Ferguson permits the states to regulate insurance, and some opine that this fact effectively prohibits the sale of insurance across state lines, because the states have the exclusive power to regulate the insurance policies bought and sold within their jurisdictions, free from federal intervention. It seems reasonable to suggest that federal intervention is necessary to permit the sale of insurance across state lines. It appears that all an act of Congress would have to do is properly and expressly purport to regulate the business of insurance. I would conclude that Obamacare is unconstitutional because of two main reasons. The first reason is that it does not expressly purport to regulate the business of insurance. With such a claim, the federal government could easily justify intervention in order to permit insurance transactions across state lines, preempting and invalidating state laws on such matters, and most likely reducing premiums in the process. The second reason Obamacare is unconstitutional is that instead of properly invoking the aforementioned power in order to reduce inhibitions on the sale of insurance, the Kucinich Amendment to Obamacare, which permits each state to implement a single-payer health insurance system, effectively allows for the possibility that any state can erect for itself the sole and exclusive power to regulate health insurance within its territory, and the monopsony power to purchase health insurance on the behalf of its citizens. I would add that, in my opinion, the Affordable Care Act in permitting the creation of such coercive monopolies violates the Sherman Antitrust Act. What this means is that not only does Obamacare cite the wrong power to achieve its purported ends, part of it actually defeats the very goals which are claimed to have been the law's chief objectives, namely, to increase competition and reduce inhibitive economic activity in the health insurance business, and to drive down costs of healthcare insurance premiums. Costing somewhere in the neighborhood of a combined $2 trillion to implement new regulations as well as changes to existing programs, and causing some 2.5 to 3 years of discussion, the Patient Protection and Affordable Care Act has been a colossal waste of time, money, and public attention. There truly is a need to reform the status quo of the insurance business in this country. But given what one source estimated as an approximately 80% chance that at least the individual mandate will be overturned, and the fact that inappropriate power was cited in order to defeat the very purpose of the legislation, it is clear that this legislation, which, if upheld, will be the best known, well-renowned, and longest-lasting legacy of the Obama administration, is nothing more than a costly, thoughtless, ineffectual distraction from much more pressing issues. Even so, in the aftermath of rapid decline of home values and out-of-control bailouts and major fiscal exposure, at a time of record deficits and national debt, economic stagnation, rapidly increasing disparity of wealth and income, an upswing in domestic surveillance, and heightened geopolitical tension, not to mention the very rising health care and insurance costs which were supposed to be addressed by the Act. Because they are outside the scope of this video, which focuses on the relationship between Obamacare and the ICC, I have neglected to mention several important factors relating to more broad questions pertaining to the law's constitutionality. They include taxing authority, issues pertaining to the interpretation of the General Welfare Clause, the constitutional legitimacy of the Presidential Reorganizational Authority, which was cited in order to establish the executive branch departments, which were the progenitors of the modern Department of Health and Human Services, and whether the law's provision that the federal government will withhold Medicaid funding from the states if they do not expand coverage for the poor constitutes unlawful coercion. I will end by noting that it has been reported that the justices of the Supreme Court are not positive that now is an appropriate time to rule on Obamacare. This is because the Anti-Injunction Act provides that a taxpayer may not challenge a law until it goes into effect and the taxes enabling it have been assessed, which will occur in April 2015, just under 3 years from now. Although it has been reported that Associate Justice Anthony M. Kennedy's opinion will most likely be the deciding factor, that one of Kennedy's former clerks thinks Kennedy will vote to uphold the law, and that avoiding making a decision on jurisdictional and Anti-Injunction Act grounds may appeal to Kennedy, it has also been reported that several of the justices seem skeptical that the act would prevent the individual mandate from being challenged this early, and that the vast majority of the interested parties involved in the suit believe that the act should not apply. Additionally, I would like to thank former Wisconsin Libertarian Party officials Rolf Lindgren and Ben Olson III for their assistance finding reference materials for this video.